In the same way, a single member company can be, a private company, limited company can be converted into a single member company and vice versa. Under Section 47, paragraph 1, a private company may be converted into a single member company, and there are also two requirements. Requirement number one is the prior approval. A private company cannot be converted into a single member company unless a prior approval has been sought from the Security and Exchange Commission of Pakistan. And again, Security and the authority, the concerned authority at the Security and Exchange Commission of Pakistan is not going to, agree, is not going to allow a private company to convert itself into a single member company after, without getting convinced. So if the authority at the commission got convinced that it is essential or it is beneficial for the private company to convert itself into a single member company, the company would be allowed. And number two requirement would be amendment. Naturally, obviously, amendment would in the articles of association as well as memorandum of association would be essential to convert this company constitutionally in black and white, writing. And as you know, in this case as well, a special resolution would be needed. There are matters which are decided by simple resolution, by simple majority. But these are essential matter. The very nature of the company is being changed. That's why the resolution which would be needed for approving this amendments or alteration of a memorandum of association and articles of association would be a special resolution. And you know it very well that a special resolution is that resolution which is supported by 3/4 majority of the shareholders. So this is the procedure of getting a private limited company, converted into a single member company. There are cases in which a single member company, can be converted if a company being a single member company alters its articles. A single member company can sometime be converted compulsorily by operation of law uh, into a private limited company. In what circumstances? When it alters its articles of association or memorandum of association and it removes the characteristic of a single member company from the memorandum and from the articles, then section 47 subsection 5 of the company's ordinance 2017 says that the effect of this amendment, the effect of which amendment, if a single member company alters its articles and its memorandum in such a way that the characteristic of a single member company are removed from its memorandum and articles. The effect, according to section 47, subsection 5, would be that as on the date of alteration, this company would cease to be a single member company. And it would be no more single member company, and automatically it would be treated and considered as a private limited company. And for being a private limited company, another, at least one more shareholder would be needed. As you know that in a single member company, the shareholder is one. If one person can register a single member company. So if this amendment is made, then from the date of amendment, from the date of alteration, it would cease to be a single member company. And consequently, it would be treated and considered as private limited company. And then number two effect of this alteration in the memorandum and article would be that the company would be bound to file with the registrar a copy of the memorandum and articles of association as altered along with the special resolution. And again here, under section 46, if default is made, if this, you see, these documents are not filed with the commission, then uh, every officer of the company who is in default shall be liable to a penalty not exceeding of level 2 on the standard scale. There is a penalty prescribed by the Act of 2017, so they will be liable to this penalty. Okay. Again, you see a single member company, the chief characteristic of a single member company is that there is just one member. If you see, if a person has registered a single member company and he invites another to join him, so it means that he has removed the essential characteristic of a single member company. So then he will have either to reduce the number to one, or he would, you see, he would provide, you see, the required document to the Commission, Security and Exchange Commission of Pakistan, and from that date it would cease to be a single member company, and it would automatically, by operation of law, compulsorily would be treated as private limited company, and all the laws which are applied on a private limited company would be applied on this business entity. Okay. The next topic for today is share capital, shares and debenture of a company. What does share capital means? Section 2, paragraph 63 of the company's ordinance defines share. You see, in the following word, it says share means a share in the share capital of a company. You know it very well that a company, you see, is a company which is limited by share. I'm not talking about a company which is limited by guarantee. I'm talking about a company which is limited by share. It is registered, it is constituted for the purpose of trade and business. And for the trade and business, it needs money, it needs capital. And that capital is provided in the public limited company by the public, and in the private limited company by the shareholders privately. In both the cases, it is provided by the shareholders. Okay, so this money, or this capital of the company with which it carries on its business, with which it conducts or runs its business, is called share capital. And this share capital is divided into small fractions. Just suppose that in the memorandum of association, just suppose, okay, that in the memorandum of association, it was mentioned that the company is going to have a share capital of 100 rupees. Just suppose, with 100 rupees, you can't have your breakfast. What to say of having a company for a business? Just suppose for the 100 rupees. This is the share capital. And further, it is provided, it is clarified in the memorandum of association that the share capital of the company would be divided into 100 shares. Okay, so there are 100 shares, and the value of one share is 1 rupee. So this one share out of 100, one fraction out of 100 rupees is called a share. Okay, so this is called share, and the share, the capital of the company with which it runs its business is called share capital. Section 64 talks about the share. What is the nature of the share? It says that the shares in the business of a company is not simply a piece of paper. How shares are evidences. How would you come to know that you own one share or more? You see, whenever you wanted to buy the shares of a company, you pay for that, and they give you a certificate. Okay, it's immaterial whether when you bought 10 shares, whether they are issuing you 10 certificates or they give you one certificate. I mean, it's immaterial. Okay. Anyways, you are given a certificate which evidences that Mr. Kala Khan has 10 shares in this company. All right. So that certificate is called share certificate. So this share or share certificate, I mean, that share certificate is called share. That is not only a piece of paper. Instead, according to section 66, this share certificate is the evidence that the shareholder has share in the capital of the business. Shares of a company are transferable from one shareholder to another shareholder. Okay. So this is not simply a piece of paper. It is an evidence that the holder of that certificate, in other words, the shareholder has a share in the company's business. Okay. And I have explained to you shareholders. Then coming to the definition of debenture. Debenture. There are two types of investments in a company business. Uh, oh, its number is too much, mashallah. It's 34 out of 36. So uh, people invest in the company business in two ways. Or company, you see, invites public to invest in its business in two ways. Number one method is that company invites people to come down to the company and to buy its shares. They are shareholders. Sometimes what happens that the company it has sold all its shares. Still, it is in need of money for its business. So how would it arrange? It has no more shares to sell it. You see, there is a one way which we are going to talk about today is to increase its capital. But without increasing the capital, it can borrow the money. And the money which it borrows from people, you see, that is evidenced by another certificate, which is called debenture certificate. So there are two types of investors in a company: shareholders. Shareholders are members; they take part in the conduct of business, while debenture holders, those who have invested in the money, those who have lent money to the company, they have debenture certificate. So these debenture holders, shareholders, they are sharing the profit. If the company is making good profit, they are going to get good money. If the company's business is not good, you see, they are less, they are getting less. It means that their share in the profit is fluctuating. Sometimes too much, sometimes too less, sometimes nothing. All right. As against this, a debenture holder who has lent money from whom the company has borrowed money, since he is not a shareholder, he is a creditor. He gets a fixed amount as interest. Fixed that amount is fixed. Whether company is earning millions and trillions, or company is at loss and it is not earning a single penny, the debenture holder is, you see, every year getting an amount fixed for him. Okay, this is difference between a debenture holder and a shareholder. A shareholder invests money, and on his investment, he shares the profit of the business of the company, while the one who invests in the form of debenture, in the form of, you see, lending money to the company, he is getting a fixed amount as interest. He is called debenture holder. Another difference between these two category of investors is that a shareholder is since he is a member, he take parts. He has a right of vote, while a debenture holder, he has no say in the company's proceedings. He has to play no part. He's not invited to come and attend the meetings of the companies because he's not a member. The last 2 points which I have chosen for today is increase and decrease, reduction of capital. If the company's business is good, and it is in need of some extra money to be invested in its business, it has got more contracts, etc., then I told you two ways: either to borrow money by issuing debenture certificates, or to increase share capital. So share capital, the amount of share capital is fixed in the memorandum of association, and if a company wanted to increase the share capital according to section 85, you see, if it is authorized by its article, the you see, alter the condition of the memorandum through a special resolution. So through special resolution, it can, you see, amend its memorandum of association and allowing itself to increase the share capital. If the share capital of the company was just 100 rupees, now they have got so many construction contracts. They need, you see, another 200 rupees. So either to borrow it and issue in the form of, you see, debentures, or to sit together and to pass a resolution, special resolution, and to increase it to 300 rupees. So increase, a company can increase its authorized capital by such amount as it thinks expedient. In the same way, under section 89, it can reduce as well. Okay, why it should reduce its share capital? Obviously, if the business is not good, you see, and the shareholders are 100 and they are asking for profit, so they can decrease. You see, and for decrease or for reduction of the capital as well, under section 89, a special resolution would be needed. You see, the memorandum would be amended. So section 89 says that a company may reduce its share capital. However, you see, there is a big difference between increase. For increase, only and only, you see, alteration of memorandum. But for decrease, a company limited by share, if so authorized by its actor, may by special resolution may reduce its share capital. However, a company has this authority subject to confirmation by the court. The court confirmation is also needed. If it is not confirmation of the Security and Exchange Commission of Pakistan, confirmation by a court of law, which means that, you see, if a company has decided to reduce its share capital, naturally it would be pay off certain shareholders. Okay, just suppose that there are 100 shareholders and it want to decrease its share capital to 50 rupees instead of having 100 rupees. Naturally, it will pay off 50 shareholders their money, so that the number of shareholders are reduced to 50. Since the right of people is involved here, and you see, the right is under, you see, uh, under danger. You see, they are going to be deprived of the profit of the company. That's why law has put a restriction here, that, you see, this decision has to be confirmed by a court. Special company courts are established. The matter would be taken to the court of law after amendment. You see, the court will look into the matter. If the court is convinced that it is essential for the existence of the company, you see, this reduction, then it would allow. Otherwise, the company would not be allowed to reduce its business. Uh, how can it reduce its capital? Canceling any paid off share capital which is lost or unrepresented by available assets. Just suppose that the company has some shareholders, but shareholders are, you see, not known. They are disappeared. That the share can be cancelled. And in the second way, it can pay off any paid off share. It can negotiate with few of shareholders, and can get them convinced that they should surrender their shares to the company and take their money back, so that the capital of the company is reduced.